It's a great day for Britney Spears, and it's a great day for justice.
In July of this year, after 13 years under a conservatorship, Britney Spears was allowed to choose her own attorney, Matthew Rosengart.
And she's so pleased and she's so thankful to all of you.
A life-altering move for the singer whose life has been controlled since 2008.
Britney Spears' father, Jamie, is no longer her conservator.
Matthew Rosengart, Britney's attorney, telling me just as he left the courtroom, I left it all out on the field, and the judge did the right thing.
It's something that seems like a basic right for anyone, let alone a superstar. Choosing your own legal counsel, someone that will stand for you and you alone.
Ethically and by law, you are supposed to advocate for the expressed wishes of your client.
The right to counsel is part of the United States Constitution, as due process protects the right to choose your own attorney. It's also written into the probate code, the regulations that guide conservatorship proceedings. But despite being a basic right, our ongoing investigation found that the right to choose your own counsel or even have counsel isn't happening in many conservatorship cases across California.
The judge pushed Teresa's chosen attorney off the case and put in a guy who was the same age as Teresa, an 82-year-old, to defend Teresa.
There was an attorney appointed for my brother that was supposed to look in his best interest. Never knew who he was, never saw him, didn't even know his existence.
And the judge said, "You can't do that." "What do you mean I can't do that? I'm our attorney." And this was done before. He says, "Well, we've already appointed Mr. Risley to be her attorney." Basically, it's violating the Constitution, it violates the California Code, it violates the probate code.
I think sometimes it happens because the attorney that the person brings in to represent them isn't part of the good old boys network, isn't part of the system. And so the judge is thinking, oh boy, this attorney is going to make waves.
Making waves in court could mean demanding hearings, demanding jury trials, and challenging fees, to name a few. And all of those take time, something judges don't have.
Finally, a judge says, "You're taking too long and you're delaying this case." I think my comment was, this whole case should have been thrown out at day one.
The best way to make them go away is to have the attorneys surrender the rights, rubber stamp it, feed them into a conservatorship, and go on to the next case.
Probate courts throughout California are overloaded, and conservatorships are often cycled through being appointed and taking away someone's rights in just minutes. But as of January 1st, 2022, this process should change.
Governor Newsom has just signed AB 1194. AB 1194 deals with conservatorship reform. Part of that deals with attorney reforms. It requires the judge to allow the person to have the attorney of their choice. No ifs, ands, or buts.
But some individuals that may be placed under a conservatorship sometimes lack the money or the mental capacity to hire their own attorney. AB 1194 would change that too.
The next thing it says, if the person doesn't have an attorney of their choice, the court must appoint an attorney.
That hasn't been in the rule?
No, it was discretionary.
It's one of the many things the conservatorship bill aims at reforming. Other changes include creating communication between courts and the Professional Fiduciary Bureau, the state agency entrusted in overseeing fiduciaries that serve as conservators. Requiring more transparency, like specific data on the number of conservatorships statewide to be reported, and more requirements for court investigators, like talking to first-degree family members prior to the appointment of a conservatorship. But it's not the first piece of legislation that's made an attempt to change this multi-billion-dollar industry that controls the lives and money of others. In fact, the American Bar Association said since 2011, U.S. states have enacted approximately 343 adult guardianship bills. Yet, issues continue to arise.
Free! Britney! Free! Britney!
In a 2007 Reform Act, a nearly identical bill was passed here in California, but failed to change anything.
After doing our own research on the California's conservatorships laws, we found that a huge effort to reform the system in 2006 did not take effect due to the toxic economic recession that started in 2008.
But Assemblymember Lowe, who introduced AB 1194, hopes his bill will create the change the system needs.
Does your bill give funds, or does it address that? Because it's kind of doing the same thing the 2007 Reform Act did, if it doesn't.
Right. Part of the legislative proposals that we have too is ensuring that we have the policy that was supported and make sure that the resources to empower local communities to implement the law.
For other activists, they believe it's a step in the right direction, but the first of many needed.
There's no magic wand approach. It's not instant reform. AB 1194 is a tool that's going to help those of us that are committed to this reform keep pushing step by step.
The conservatorship has got to go! Hey, hey!